Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Graham.
Your name?
Dear Graham.
Thank you. What are we doing?
Your Honor, at this time, Mr. Graham has indicated that he is not interested in any kind of plea agreement. He wishes to set this for preliminary examination and to have our office address bond.
And what?
And to have our office address bond.
So discovery is complete.
That is my understanding.
Do you have other witnesses available the 27th?
Yes, sir.
Preliminary examination in person, January 27th, 2026, 9 a.m. before Judge Washington. Bond will continue. Or you want to address bond? Go ahead.
Thank you, Your Honor. Your Honor, Mr. Graham is indicating that he has stable housing. He has Section 8. He is asking that the court consider that so that he can return to his housing and not and be able to maintain his voucher. He also is in the process of gaining custody of his son. He indicates that he does have a friend of the court hold.
That's what?
A friend of the court hold out of another county for his child, and that he believes he will be able to post for that as well. Post for that.
The friend of the court?
To the friend of the court to a different county, and that he will be able to make that payment towards his arrearage to that court and would be able to be released if Your Honor would allow him to have a personal recognizance fund. He's also an entrepreneur. He has his own business.
Response?
Your Honor, the people would oppose reduction in bond. The defendant in this case said harassing text messages to the victim, in which he says, "I'm about to go to jail, fuck it, I just want this shit over with. I promise one of us is about to die tonight." Those statements are of great concern.
Those alleged statements are from July.
From what?
From July of last year.
So that makes it better?
Mr.
Go ahead.
No. What I'm going to say is that Mr. Graham was unaware of the warrant and that this was pending. However, there's no allegations that I have heard that there's been anything since that July 2025 incident. So in 6 or so months.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Jay Ballinger on behalf of Ms. Wittenberg. Ms. Wittenberg, can you please state your name for the record?
Alicia Wittenberg.
Thank you.
And Your Honor, we are here for PCC today. I just received an email earlier this morning, and I haven't been able to unfortunately do anything with it, but from 14B stating that she has been accepted in the 14B recovery court.
That she has been?
Yes. So the MOU would still need to be filled out, as well as the plea form, advice of rights, et cetera. So I would need an adjournment to accomplish that. It is. I did also submit an email from Sarah Stewart to the court. I was able to speak with her yesterday with regard to the insurance situation that Ms. Wittenberg brought up last time. Unfortunately, it's just not going to happen that she is able to get into inpatient from the jail with her insurance.
Right.
So I would plead with this court to allow her to be released on PR. She's been accepted into recovery court. She can come back for a plea.
There's going to be a plea though.
Yes, Your Honor.
So how soon are we going to be able to work up the plea?
I imagine we can get that done as early as next week if the court would allow.
And what I'll do, if she's going to go, I'll adjourn it out 1 week. I'll take the plea. Once the plea's done, then certainly I'll consider release of some type of factor.
Okay, Your Honor.
All right. But I want her. I'll adjourn this then to January 22nd, 2026, 9 a.m. Bond continued.
I will have everything ready for you.
If they can get everything written up, then we can get her on her way into that and insurance. Okay.
Okay, thank you.
Thank you. Court calls the case, People versus Zariah Griffin Bills.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Griffin Bills, who approaches.
I want to hear.
Hi, I'm Zaria Griffin.
Hold it. Say it.
Zaria Griffin Bill.
Zaria.
I'm so sorry.
No, I think I messed that up the last time.
I've been contemplating it back and forth in my head too, Your Honor.
Well, when I said it, I realized, I don't think that's. All right.
Your Honor, I am just asking for a brief adjournment. We did submit mitigation on this. We're just waiting to hear back about that.
I got it. Probable cause conference, February 5th, 2026, 9 a.m.
Okay. Monday.
It's going to be on a Thursday.
Okay, perfect.
All right. Bond will continue. Sorry, right?
Do you need a sheet to remind?
Oh, I remember today.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case, People versus Gage Hammond.
You're ready to cook for the people?
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Hammond, who stands to my right. Please state your name for the record, sir.
Gage Hammond.
All right. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Solemn swear or affirm the testimony you're about to give you the truth, the truth, and hope you got it. Lower your hand, state your name and spell it.
Gage Hammond, Gagehammond.
Mr. Hammond, it is this court's understanding you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Understood.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, understood.
All right. Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, understood.
You signed or had cause to have signed an advice of rights form. Is that correct?
Yes, yeah,
Any question regarding any of those rights?
sir.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes?
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
yes,
Okay, were you on probation at the time of this offense?
yes,
All right, then I do have to advise you that your entry of a plea in this case could be a violation of your probation.
yes,
You understand that if it is considered a violation of your probation, you could be sentenced to the maximum term allowable by that other court. You understand that?
yes,
Yes?
yes,
Understanding that, you still wish to plead guilty in this case?
yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 25th, 2025, at the location of East Michigan Avenue near Old Creek Drive in the city of Saline, Washtenaw County, state of Michigan, were you in possession of methamphetamine?
Yes, I was.
Had you used it?
Yes, sir.
Did you know what you were using was the methamphetamine?
Yes, sir.
Sir, if I accept your plea, and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any evaluation or recommendation regarding sentencing, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4. Sentencing in this matter will be
At 9 a.m. before Judge Freshour.
February 17, 2026, 9 a.m. 9 a.m. before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case of the people versus Kristen Guevara.
Hannah Mackey on behalf of Mr. Guevara, who is approaching. Your name.
Christian Guevara.
Your Honor, we're asking to adjourn this matter. We are negotiating something with the prosecutor at this time.
probable cause conference will be adjourned February 5th, 2026. 9 a.m. bond continue.
Thank you, Your Honor.
Thank you.
I'll touch you.
Awesome.
Court does call the case of the people versus Summer Johnson. Who's in custody?
Morning, Your Honor, Raymond Cook for the people.
Hold on a second. They're not up yet. Let me try this one. Nicholas Harding. Go back, Glenn.
Assistant Public Defender Deputy. Yes, sir, Nicholas Harding. Assistant Public Defender Deputy before Mr. Harding. And during the requesting adjournment, we are currently negotiating.
Public cause conference, January 29th, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
There you go. Court. Recalls case people versus the Mar Johnson.
Morning again, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
You're still under canon?
Yes.
Wow. That it was like a whole new semester. That's something good might happen for you. Okay, permission to practice.
Thank you, Your Honor. Can you state your name for the record?
Mar Johnson. Thank you. What are we doing?
Your Honor, we're requesting to set 1484 for preliminary examination and an adjournment for 1487.
The cases aren't related. Really.
They are, I believe they are.
Pardon?
I believe they are related.
They are related, Your Honor. It's an RNO stemming from the home invasion. They're charged as two separate cases.
Got it. That's what I was wondering. So why would I do that? Set one for preliminary examination and then adjourn the other. Ms. Glenn.
Your Honor, our client is requesting a preliminary exam because he believes that
Back up, Cannon. Why would I set a preliminary examination basically on part of a case? I realize they're charged separately, but why wouldn't they be held together? Well, let me ask this. Wouldn't it make more sense if they were held together?
I think so. Mhm.
So I guess then where are we at with the one that you want the adjournment on that would stop us from going forth on a preliminary examination on that one? Hold it. Hang on a second.
Yes, sir.
Sir, you're good. Don't worry about it. Cannon sent you up here to do this, didn't she? And she knew. Ms. Glenn, you've been set up.
Your Honor, may I?
I think you're gonna have to.
I see this. The home invasion case, we're waiting for DNA on. I don't have the DNA back as of yet. And we do think that that is pertinent to the case.
Got it.
The RNO, and it's my opinion, is tangent to that. While they were out looking for a possible suspect, they allegedly came across him. So he's not in the house, he's not doing anything, he's just.
But is this like
kinda out and
shortly
about.
afterwards? I mean, the problem's gonna be, there's going to be some testimony, I would suspect, that relates to the one case to show that the officers were acting lawfully.
Your Honor, our client said it was 4 days after.
But even, I mean, go ahead, Mr. Cook.
Your Honor, so the R and O released to the arrest on this, but it was a couple days later. They were searching for the suspect. If the court wants to set the R and O for exam, I think there's sufficient separate to where I could run that exam.
Without mentioning or getting into the other one.
If defense counsel is willing to, I guess we can have a conversation about possible stipulations for exam purposes as to that. Just trying to think of a way to make this one suit.
It was like 3 days later, Your Honor, and I think it's even different officers. I mean, I guess they could say.
Right, but then the question becomes, does it not? Why are they, I don't know what the alleged resisting is, but why are they detaining him? That then gets into these other events, right?
I know you really, no, I know you really want it said. I know you do, but what the court is saying is that they may.
I mean, I'll do it, but I'm just saying.
Why does they after me in the first place?
Okay,
You gotta tell them that.
I understand. Just hold on. Your Honor, my client really would like to have this preliminary exam held. I can go over this with him again in more detail. We've discussed this type of stuff. He wants the exam. Are you holding it? I can work with the prosecutor on certain stipulations so that certain things may not need to come out.
The problem is, this is all gonna have to be, if I set it for the 27th, all this is gonna have to be explained to, here's what I'm doing.
Thank you, Your Honor.
I'll give you your preliminary examination in person. That'll be February 3rd, 2026, 9 a.m. That's before me. So that we don't run into any problem with why this one is set and what the court's gonna require. Then in the other matter, you're seeking an adjournment.
Yeah.
When is the DNA expected back?
6 months.
That I don't know.
In this matter, will be adjourned. I'll just set it for February 5th, 2026. 9 a.m. bond continued.
Thank you, Your Honor.
Days People versus Chalice McLaughlin.
Alex Chavalowski, the people.
Sorry.
Wow. It was not you. You just happened to be in the area.
Yeah.
No, I saw it was Mackie.
I feel like it was not me, but
You feel like it wasn't you? Okay.
someone overreacted.
McLaughlin?
Not out there.
Is he in custody? He is. You guys have, or you're waiting on it? Oh, there you go.
Anna Mackey on behalf of Mr. McLaughlin, who's approaching.
Alex Chavalowski, the people. Good to.
You say your name.
Your name?
Alex McLaughlin.
All right, what are we doing?
Can we approach, Your Honor? Please.
As long as you bring Miss Gaines, yes.
Thank you.
I don't trust Chavalowski.